Let's move to SEC versus Jarchese, or Jarchese.
I think it's Jarkisy.
Jarchese.
Yeah.
This is a case which, and I don't know for how many years that we've been having you on, and we've been talking about things like the non-delegation doctrine or the Chevron doctrine. And now the so-called major questions doctrine, which
Right.
I think you and I have actually I've been interviewing you longer than that has existed in practice. But it is one that is like sort of completely turning over the apple cart in terms of like American jurisprudence, as far as I can tell. But this concept that essentially would both and or inhibit Congress from delegating authority to agencies where they have expertise, and also the deference that courts have to these agencies when agencies are making, questions of executing and developing regulations to carry out congressional will. This is a case that could have touched upon that as well.
Yes. So what this case involves, well, first of all, the SEC is the federal agency that protects investors from fraud from the companies they're investing in. It has existed since the Roosevelt administration, and the relevant laws governing the SEC haven't been changed in more than a dozen years. So despite all of that, the Fifth Circuit, which is, the Trumpiest court in America, a court that is, seems to be looking for ways to sabotage the federal government, declared that the SEC's methods for bringing enforcement actions against people who allegedly defraud investors violates the Constitution in three different ways. Now, just as a general rule, if you have an agency that's been around for 80 years and the laws governing that agency haven't changed in more than a dozen years, and someone comes along and says, hey, I found that this violates the Constitution, not one, not two, but three different ways, don't trust that person. If there's a lot of litigation in the United States, if something is unconstitutional, it only gets noticed fairly quickly, and if it doesn't get noticed fairly quickly, we certainly don't miss three different, some of them very novel constitutional problems. So,
and particularly when it comes to something like finance, right? That's
right.
Half their job is suing the U.S. government in terms of trying to release themselves from regulation.
Right. Yeah. This is a case about securities fraud, and there's lots of money, obviously, in securities. Companies have an interest in both knowing what the law is and in challenging the law if it hurts them in any way. So, if there was a serious violation going on, you'd think someone would have found it by now, much less three of them. But anyway, so here's what the issue is that at least the Supreme Court cared about. And the good news is that the Supreme Court looks likely to shrink this case, although they still look likely to use it in order to diminish, some of the federal government's ability to govern. So the SEC has these officials that are called administrative law judges. And what administrative law judges are is they are judges who are experts in securities fraud. And so if the SEC brings an enforcement action against someone, in this case they brought it against a hedge fund that's accused of defrauding its investors, they have the option, instead of bringing it before what's called an Article III court, sort of generalist courts that hear all sorts of issues, they have the option of bringing it before one of these administrative law judges. And, a big reason why the SEC would want to do that is because these judges actually know what they're talking about. Securities fraud is really complicated. You want judges who understand, not just the law of securities fraud, but that understand the business here, understand the concepts that they're going to be dealing with, because people who know what they're talking about are more likely to get the answer right. And so that's why you have these administrative law judges. The Supreme Court seemed very concerned that this administrative law judge process doesn't allow for jury trials. And, again, I think the reason why it doesn't allow for jury trials would be pretty obvious, because the whole point of these administrative proceedings is that you want the case to be heard by an expert and not by, 12 randos who probably know nothing about securities law.
And we should say these are not criminal cases, right? These are civil cases.
Yes. Yeah, that is an important point. These are not criminal cases. If you're being accused of a crime, you have an absolute right to a jury trial. That's the Sixth Amendment. If you're not accused of a crime, if it is a civil case, the Seventh Amendment to the Constitution says that in some civil cases you're entitled to a jury. But the phrase that it uses is at common law. Like, basically it means that you are being sued under a provision that, under a legal doctrine that derives from common law principles that have been around since like the pre-colonial years, rather than being sued under a statute, rather than being sued under an act of Congress. But in any event, the Supreme Court, based on at least what I heard in the oral argument, probably isn't going to accept any of the more Baroque, like, let's destroy the whole federal government's ability to operate theories that the Fifth Circuit latched onto. But I think it is likely to say that these sort of expert forums that exist probably cannot continue to exist, at least not in their current form.
And we should say that, like, the number of administrative courts, if you will, in the federal government, like, we're talking like we have this in immigration, we have it in, all sorts of like regulatory enforcement in the country. It would be devastating. And not to mention, just like from a practical standpoint, like, you would have to ramp up the federal judiciary. But but in terms of like having judges not be sort of, I guess, all political appointments as well, so that we could know before someone even gets into the courtroom how they're going to rule on this case. All right. So your sense is that is going to remain intact, and that's not going to be that much of a problem, although they're going to do their best on this. Let me just ask you this. Why does the Supreme Court hear these cases that like seem like they're swinging for the fences?
Yeah. It's an excellent question. And it's a particularly good question because at least this term, it seems that, like, even in this right-wing Supreme Court, a lot of the justices are looking at some of these cases going, whoa, that's too far even for us. So I think there's a few phenomena going on here. One is just that lawyers are smart, and when they see the Supreme Court move to the right-wing lawyers will bring more cases, and, more lefty lawyers will not bring a lot of lawsuits because they don't want to lose. And so you see more Hail Mary cases being brought because you just have more right-wing lawyers saying, well, now I've got a shot with this with this argument. So that's one phenomenon. The second phenomenon is you have judges, especially on the Fifth Circuit, but, in other places too, who are very partisan, who want to push the law to the right, who want to force the Supreme Court to hear issues by, like, striking down some exorbitant amount of the federal government and then requiring the Supreme Court to step in and pick up the pieces. And you also have a lot of judges on these lower courts who are auditioning, who want Donald Trump to promote them to the Supreme Court. And they think if they make a big splash and show, like, look, I'm on the cutting edge of Federalist Society thinking, that, this will help them catch the eye of a Republican president in the future. So, you have a few phenomenon going on here.
Let me just explain, or have you explain to people, like, so if you're talking about like the Fifth Circuit which you describe as the most Trumpiest of circuits, you're talking about 5 or 6 states. I can't.
So the Fifth Circuit is Texas, Louisiana, and Mississippi.
Okay.
So if you bring a federal lawsuit or you are sued in Texas, Mississippi, or Louisiana, when your case is appealed, it will go to the Fifth Circuit.
And the reason why the Supreme Court needs to hear that case is because if they were to rule that the SEC can't use administrative judges out of the Fifth Circuit, and that was to let stand, and the Supreme Court didn't address it, then in that jurisdiction, they wouldn't need to use, they wouldn't be allowed to use administrative judges, right? So the Supreme Court is obligated to hear that case.
Pretty much, yeah. I mean, they're not literally obligated in the sense that, like, nothing's going to happen to them if they don't hear the case. But the point of the Supreme Court, the reason why we have one court at the top of our whole judicial system, is to maintain the uniformity of federal law. You don't want a situation where federal law means one thing in Michigan and means a completely different thing in Texas.
Is there a dynamic where Roberts, at this point, in the wake of Dobbs and in the wake of like these clear ethical issues that the court is having, that Roberts is like, if we can have cases where, the question is around, should we essentially have a functioning federal government, and we weigh in with a result that is yes, okay, a begrudging yes. I mean, is this part of Roberts' sort of like mentality of like, I need to bail some water here at a time where the Supreme Court legitimacy is in serious question?
Yeah, I mean, my short answer to that is you'd have to ask John Roberts that.
Right.
But like, just as from what I can tell from the outside looking in, like the Supreme Court, this group of Republican justices, the 6 Republican justices who sit on the Supreme Court right now, came in with a pretty clear agenda. They had like a list of boxes they want to check. We're going to get rid of Roe v. Wade. We're going to get rid of affirmative action. We're going to give ourselves a veto power over any decision made by a federal agency. We're going to give religious conservatives, and specifically Christian conservatives, broad exemptions from following federal and state laws. Like, they had an agenda. And I even wrote a book about that agenda called The Agenda. And as it turns out, they have now fulfilled that agenda. Like, they have checked all their boxes on the list. And so one possibility is that Roberts and maybe Kavanaugh are looking back and saying, man, everyone hates us right now. We should probably hand the liberals some victories so we don't look like a bunch of partisan hacks. The other more optimistic possibility is what's going on here is they've come in with their checklist of things that they're going to accomplish. They have now finished they've now checked all the boxes. And so having checked all the boxes, they still have a job as a Supreme Court justice, and they still have all these cases coming. And in the absence of the agenda, the optimistic take is maybe they're going to be real judges now. Maybe now that they've done all the things that they were picked to do, maybe they're going to try to be real judges now. I think we need more information before we know which one of those is the case. But it does seem to be that in this term, they are trying to rein in the most absurd elements of the judiciary after spending the previous 2 terms checking off a bunch of boxes on an agenda list.